Welcome everybody. My name is John Tehranian. I'm a founding partner of One LLP, a 35 attorney law firm with a focus on entertainment and intellectual property issues with offices in Beverly Hills, Newport Beach, and Del Mar, California. I'm also the Paul W. Wildman Chair and Professor of Law at Southwestern Law School in Los Angeles. And today, it's my pleasure to bring you a follow-up to my prior talk on the history of whiteness, or everything you've always wanted to know about race, but were afraid to ask. This is part 2, and just by way of introduction, my views here are strictly my own. They are not mine, not the views of my clients or of One LLP or any of my employers. Today's focus is going to be on the issue of race in the present. Last time we focused on the historical construction of race in American history. And this particular time, we're going to look at the issue of selective colorblindness and the evolving geographies of whiteness. Following Barack Obama's election in 2009, all of you are familiar that there were trumpets of post-racialization that sounded throughout the land. Numerous observers hailed the new post-racial environment. We were told that finally, we have entered into a new era of color blindness. But 8 years later, headlines illustrate the continuing vexing issues of race that continue to plague modern American life on a daily basis. From the tragic events of Ferguson and Charleston, the controversy over the Black Lives Matter, the revival of populist white supremacy, to the alarming rise of hate crimes, Donald Trump's call for a ban on Muslim immigration, and the threat to build a big, beautiful wall along the Mexican border. Obviously, issues of race continue to permeate our political and legal discourse. This talk is going to examine what we are to make of this promise of color blindness, both as an aspirational social goal as well as a purported hallmark of our Constitution, and evaluate it in light of our current circumstances. In the process, we're going to be talking about, first, an assessment of color blindness in fact versus theory, using the example of the racialization of former President Barack Obama in popular circles over the past decades. We'll then turn our attention to a historical discussion of the notion of color blindness in constitutional jurisprudence, from all the way back to Plessy v. Ferguson and Brown v. Board of Education, to the more modern jurisprudence of both the Rehnquist and Roberts courts. We'll then engage in a critical comparison of the trope of color blindness in the context of affirmative action, voting rights protection, and other remedial race-based cases on one hand, versus the absence of the trope of color blindness in a series of cases involving criminal law, immigration, and terrorism-related cases on the other hand. In the process, we're going to dissect the ways in which courts have adopted a form of selective color blindness that has given legal legs to some of the apparent proposals of the Trump administration. And finally, we'll look at some recent legislation in Arizona, including SB 1070, which is Arizona's Show Me Your Papers law, as well as HB 2281, which is Arizona's legislation outlawing ethnic studies programs in public schools, as well as recent proposals by the U.S. Census Bureau to change the way race is being counted on the 2020 census. And we'll look at how the selective invocation of color blindness can in fact be a way to reestablish or reintroduce white geographies. In other words, geographies or spaces characterized by an implicit hierarchy that privileges white racial identity. Hopefully and ideally, this talk will provoke a serious dialogue about what equal protection under the law should mean, the value of the goal of color blindness, its possible exceptions, and recent political and legal trends that have raised serious concerns about the state of race relations in our country and the protection of civil rights for all. Now, we're going to begin by talking about the way race is popularly perceived in current American political and legal circles. In popular thought, racial prejudice is now largely viewed as an increasingly historical relic, at least among the majority of the American population. The 2011 Gallup poll found that 78% of white Americans feel that blacks are now treated equally with whites in their local communities. Of course, that view was not shared by all, And in fact, there's a striking difference about how people of different races view that question. Only 39% of individuals of African American descent believed that blacks were treated equally in their communities. Meanwhile, only 38% of white Americans believe that racism is still a significant problem in the United States. And in fact, 65% of white Americans believe that there is little difference between the economic and social conditions of whites and blacks in our society. Now, however one might want to quibble about these views, that latter fact is unequivocally untrue, at least from an economic data point of view. One can argue about whether whites or blacks are treated equally or not equally on a variety of indices in American society, but economically, the data is quite clear, as we will see, and the data is actually quite alarming. Finally, Michael Norton and Samuel Summers performed a study, two researchers, that found on average, white Americans now view anti-white bias as actually more prevalent in our country than anti-black bias. So from this, we see that there is an increasing historicization of racism, at least amongst the white American population. And if anything, the continued perception among a majority of white Americans is that, if anything, the racism has shifted into anti-white racism. Meanwhile, African Americans continue to perceive that there are significant racial gaps and racial discrimination in our society and do not agree with the majority view of white Americans. Now, one can quibble, as I said, about the various positions of people on this subject. But one thing is certainly true, as we shall see in a moment, which is that the economic conditions of individuals of African American descent vary radically from those of white Americans. What you see on your screen now is a census, is the results of the census from 2010. This is the most up-to-date information we have. And it examines, this data, the average wealth of households based on race in the United States. We see that in America in 2010, the average white household had a wealth of $110,000. By contrast, the average black household in the United States as of 2010 had a total wealth of just $4,995. In other words, the racial gap in terms of wealth by household is 22 to 1. White households control 22 times as much wealth as black households. These numbers are alarming. They are also something that goes against the traditional narrative we have on race, which is that conditions are improving. In fact, these numbers, since the Census Bureau started keeping track of this some 4 decades ago, are the worst numbers in terms of the ratio between whites and blacks that we have ever seen. So in fact, this economic disparity between African Americans and whites is growing, not diminishing, contrary to the standard narrative on progress in race. All the while, we continue to see race at the majority level historicized. So, for example, Arizona recently passed legislation, HB 2281, outlawing ethnic studies programs in their public schools. This basically means that racism can be taught as a historical phenomenon, but teachers in Arizona in the public schools can no longer advocate ethnic solidarity or design curriculums that are designed primarily for pupils of a particular ethnic group. In large part, this is premised on the notion that racism is dead and that racism was a historical phenomenon that is no longer plaguing our country. This is echoed in legal sentiments. Very famously, in 1995, in a decision called Adirondack Constructors v. Pena, Justice Scalia wrote, "In the eyes of the government, we are just one race. It is American." And in 2013, Chief Justice Roberts, in writing the majority decision in striking the constitutionality of one aspect of the Voting Rights Act, wrote, "This country has changed. The Voting Rights Act is based on 40-year-old facts having no logical relationship to the present day." In other words, the idea is racism is over and we can now move on. with a colorblind view of the Constitution. However, as I mentioned from the point of view of economics, the data seems to suggest otherwise. The census data I presented earlier is a stark reminder of the enormous disparities that obviously have accumulated over the decades and over the centuries between white Americans and black Americans. And the news isn't that much better for other ethnic groups. If you look at the census data from 2010, the average Hispanic household had a wealth of just $7,424. Still, about a 15-to-1 ratio to the wealth of whites. Even Asian Americans, who are often held up as a model minority who has succeeded in the United States, still face a tremendous wealth gap vis-a-vis white households. The average Asian American household has a wealth of approximately $70,000 in comparison to the $110,000 of the average white household. We also continue to see the persistence of race and racism in our culture. I'm providing you a small example, one that really has received very little media attention, but I think is very captures the sense of racial thought that has occurred in some parts of the country and continues to. This particular video, or rather picture on your screen, is a depiction of a group of what looks to be Westerners or cowboys with a man hanging. And it says at the bottom, "Let's play cowboys and Iranians." The individual who has a noose around his neck is dressed in what is purported to be traditional, maybe Middle Eastern garb, and is the stand-in for the designated Iranian, whereas he is surrounded by a militia of all white, all male individuals with guns and cowboy hats. And the individual to the left of the hanged man has on his t-shirt, a t-shirt that says "Iranians suck." Where is this painfully racist and violent image from? Well, it hangs to this very day in a barbecue joint called Non-Mockers in Katy, Texas. The barbecue joint, until recently, was owned by John Non-Mocker. He recently passed away. And he has had that sign up there for some 20 years. And upon receiving complaints about it and some media attention a number of years ago, he unapologetically wrote that he will not take down the sign. He said, "This is America. If they're not happy here, then they should go back to Iran. It's my choice to have it up. It's your choice to go where you want, but I'm not going to take it down." Now, this particular image is a remarkable image because although it doesn't expressly involve traditional American tropes of anti-black violence, it is evocative of exactly the traditional Southern lynching narrative, where a group of white men would take an African American and hang them by a tree. Except here, instead of an African American, we have an individual of Middle Eastern descent. And this particular image, by hanging a Non-Mockers, is basically sending a signal to all who enter its space that this is an area, a space that privileges white identity, that those who are foreign or outsiders, be they Middle Eastern or in fact black, because the lynching narrative of yore is being re-examined and brought up again through this image, are not welcome. And yet it remains up. President Obama, of course, famously had a beer summit involving Henry Louis Gates after he was mistakenly arrested by the Cambridge police a number of years ago for entering his own home, and addressed the issue of racial misunderstanding in law enforcement with that famous beer summit. But at the very same time, there was a mini controversy involving this particular lynching image. President Obama had no beer summit for it. The issue simply evaporated from the media. But the sign still hangs there, a stark reminder to individuals of white supremacy and of the privilege of white racial identity and the unwelcome of the other in certain spaces in our American terrain. Similarly, the war on terrorism has taken a very painful racialist angle. One can see this in the comparison of the treatment of terrorists who are of European descent versus terrorists who are not. Consider, for example, these individuals, all of them of European descent, all of them guilty of heinous, terrible terrorist actions. Robert Louis Deere, of course, planned the Colorado Planned Parenthood shooting where three were dead and 9 more injured. James Holmes, of course, was the perpetrator of the 2012 Aurora Theater shooting where 12 died and 70 more were injured. Andreas Lubitz, on the right, was the pilot of Germanwings Flight 9525, which was intentionally crashed into the mountains, leaving 150 dead. And finally, we have Anders Behring Breivik, the far right-wing perpetrator of the Norway terrorism attacks that left 77 dead and 319 injured. All these individuals are anthologized in our media coverage as loners, as people suffering from mental illness or depression, that they live on the fringes of society. We're told that they were cruel to animals or that they're peeping Toms. And at worst, they're called mass murderers. But if any of these individuals had not been of European descent, then perhaps they would have been anthologized in different ways. The perception of them would be different. There would be no hesitation to bill them terrorists. There would be also no sense of suggesting that they were mentally ill or sole lone wolves. Instead, the actions of the people that we more popularly hear of as being referred to as terrorists are attributed to their race or to their religion. They are seen as representatives of the Arab world or of Middle Easterners or of Muslims. They are not, as these individuals were, seen as individuals who were crazy, who were mentally ill, or who were acting alone and due to their sickness perpetrated heinous activities. In other words, there is a vast difference between how terrorists of European descent are treated in the media and in coverage than terrorists who are of other ethnic descent. And in fact, one can see that our particular sympathies towards terrorism and acts of terrorism are oftentimes subtly, if not unconsciously, influenced by race. Consider, for example, how we as a society responded to the horrific terrorist attack in Paris. Many stadiums flew French flags. As a country, we mourned and stood in solidarity with the people of France to let them know that we understand the horrors of terrorism and stand strong with them. Ironically, though, right around the time of the French attack, there were 2 terrorist attacks that were similarly hideous, one in Turkey, one in Beirut. There was no standing with the people of Lebanon, no standing with the people of Turkey, and saying that we stood with them in the fight against terrorism. That, I think, again, is indicative of a slightly different interpretation of how terrorism affects people in the West versus how terrorism might affect people in the rest of the world. Now, Dallas Mayor Mark Rawlings had a very interesting statement in response to calls to cease the flow of Syrian refugees into the country. This is an issue, of course, that is of ongoing concern, especially in light of the so-called Muslim ban that has been put into action by the Trump administration recently. Dallas Mayor pointed to the number of deadly attacks since 9/11 involving deadly right-wing attacks versus deadly jihadist attacks. And as you can see from this data provided by the New American Foundation as of 2015, there were almost twice as many deadly right-wing attacks in our country than there were jihadist attacks. Mark Rawlings therefore concluded, "I am more fearful of large gatherings of white men that come into schools, theaters, and shoot people up. But we don't isolate young white men on this issue. We don't say because they're youthful, they're more likely to be terrorists. We don't say because they're white, they're more likely to be terrorists. We don't say that because they're male, they're more likely to be terrorists." Such reductionist thinking would betray basic values of non-discrimination, equal protection that we adhere to. Yet, we seem far more comfortable to reduce the actions of crazy, barbaric individuals who happen to be of Middle Eastern descent to their particular faith or their particular ethnicity. The numbers, however, just don't bear it out. Again, here is a listing of the deadly attacks from since 9/11, showing that the number of homegrown terrorist, non-jihadist extremists has vastly outpaced the number of jihadist extremism. And in fact, much of the terrorism attacks has come from right-wing ideologies, oftentimes based in Christianity. Yet we don't associate Christianity with terrorism, and it would be ludicrous to do so. Again, more data here. This, of course, has led to a major policy that has been enacted under the Trump administration. One that its advocates believe is an important way to secure our borders and stop the flow of dangerous individuals into our country. But critics have cautioned is akin to a racial or religious ban on individuals from entering our country and violative of our basic values of freedom of religion and non-discrimination. Thus far as the date of this recording, courts have almost universally struck the ban, and in fact there's currently an injunction on the ban, the second version of the ban, that was upheld just days ago by the Fourth Circuit. The first version of the ban that was enacted, Executive Order 13769, basically barred for 90 days entry into the United States by citizens from Iraq, Syria, Iran, Libya, Somalia, Sudan, and Yemen, and called for the indefinite suspension of acceptance of Syrian refugees. After the ban was struck in an opinion by the Ninth Circuit, the Trump administration created a second version of the ban issued as Executive Order 13780. This order banned for 90 days entry into the United States by citizens of Syria, Iran, Libya, Somalia, Sudan, and Yemen, and Syrian refugees for 120 days. This one did exempt permanent U.S. residents and visa holders, and it dropped language that offered preferential status to persecuted religious minorities. Nevertheless, so far, courts have viewed it as akin to effectively a ban on Muslims, especially based on statements made by Mr. Trump during his campaign, as well as even subsequent to his election. Now, what's particularly interesting is the ban targets individuals from predominantly Muslim countries, although it should be noted that many of these countries have very substantial minority populations of a variety of faiths. And of course, it's primarily targeting individuals of Middle Eastern descent. Oddly enough, right at the same time of this ban, there is a policy being considered by the 2020 census, and that is the creation of a brand new racial category. Strangely, as you can find out from the first talk, The History of Whiteness, individuals of Middle Eastern descent have long been considered white by law. The American federal definition of whiteness encompasses any individual who traces his or her ancestry to the peoples of Europe, the Middle East, or North Africa. The government has recently grown concerned about this conflation of Middle Eastern people into the whiteness category and has suggested that starting in 2020, individuals of Middle Eastern and North African descent will no longer check the white box. Instead, they will have a separate category for them, tentatively named MENA or MENA, Middle Eastern North African. What's particularly fascinating about this change is effectively several million Americans will go from being white to not being white in the swoop of one change in federal law. And at the same time, although there are many people who have advocated this change, in fact, from Middle Eastern related groups have advocated this change in order to give a greater voice to the Middle Eastern community, there are many who are also skeptical of this move. Why, after 200 years of calling Middle Easterners white, does the government suddenly want to get a disaggregated count and assessment of where every Middle Easterner in the United States lives in its most invasive sort of count that is voluntary, the census? Many people are troubled and says this could only help ease policies that may in fact discriminate against Muslim Americans or Middle Eastern Americans by basically readily giving the government data that the 2020 census will effectively be collecting. data that was not previously available because Middle Easterners were considered white. The definition, of course, of what white is something that I covered much more extensively in the history of whiteness, and if you are interested in that topic, I urge you to watch that video. But to give you a brief background there, individuals of Middle Eastern descent were on the cusp of whiteness for many years, and through a series of cases litigated in the late 19th and early 20th centuries were effectively deemed white by law. This new Middle Eastern North African category is undefined, and its metes and bounds are similarly unknown. There's a debate as to what particular groups to include. Do we include individuals of Turkish descent, Armenian descent, Israeli descent, Sudanese or Somali descent? And of course, there's the question, does this policy or proposal to create a disaggregated Middle Eastern North African category actually hurt or help those individuals? Going back to the current political situation and the targeting of various minority groups, besides Muslim and Middle Eastern Americans, of course, Latino Americans have been strongly in the news, especially with all of the talk about unlawful entry into the country and Trump's proposal to build a, quote, big, beautiful wall. Donald Trump, of course, famously, in his announcement for his presidential bid, made immigration a top priority, and he particularly focused on immigration from Mexico. He wrote, or said in his initial announcement speech, quote, "When Mexico sends us its best people, they're not sending their best. Send its people, they're not sending their best. They're sending people that have lots of problems, and they're bringing those problems with us. They're bringing drugs. They're bringing crime. They're rapists. And some, I assume, are good people," he said. Now again, in a post-racial environment where race is supposedly not an issue, where we do not consider race in our government policies, the particular targeting of Mexican Americans, Latino Americans, Muslim Americans, Middle Eastern Americans is particularly troubling and goes against the discourse that seems to suggest that we have entered a post-racial world. We're now going to turn our attention to how this post-racial world has operated, this supposedly post-racial world, by using the lens of the racialization of Barack Obama through the course of his candidacy and presidency, and ask, who's afraid of Hussein? Of course, Barack Obama's famous middle name. On the screen, you see two photos. The first on the left, a photo of Barack Obama dressed in what appears to be Middle Eastern garb. In fact, he's in Africa in that particular photo. And on the right, a photograph of Barack Obama's high school yearbook page. Now, as a disclaimer, I went to the same high school as Barack Obama, and many years ago, one of my friends sent me a copy of his high school yearbook page from the yearbook to the high school Punahou in Honolulu, Hawaii. And so many years ago, I saw this, and you can see that there's a photo of President Obama wearing a remarkably large butterfly collar, playing hoops, making a reference to his Choom Gang, which is presumably a drug-related reference, as well as showing a still life with an empty beer bottle. Now, all of this could have been great fodder for political narratives in the days of yore. If you think about the famous Michael Dukakis campaign against George Bush I, there was, of course, the famous photograph of a black parolee that Michael Dukakis had released during his governorship in Massachusetts. And that image was used against him to strike fear and terror into the hearts of individuals who felt that Dukakis' softness on crime, and in particular softness on crime committed by an African American, could lead the society to run amok if he were elected president. This ad was very famous and very racial. Now, fast forward 2 decades, the forces against Barack Obama did not protest him on specific grounds of his blackness. They were not able to attack him on those grounds because, in fact, times have, in fact, positively changed. But while Barack Obama could not be attacked overtly on his blackness. His otherness was regularly attacked. And the supposed color blindness that we were showing in our 21st century political and legal environment was certainly not extended to him. Obama was not attacked for his blackness overtly because that is verboten, but he was attacked for his skin color, for his background on many other levels. So, for example, Sarah Palin, of course, talked about Obama palling around with terrorists, and there was a whole subtext that Obama was somehow some kind of Manchurian candidate planted in the United States as a subversive agent. On the campaign trail, a woman famously told John McCain, "I don't trust Obama because he's an Arab." John McCain's response, unintentionally hilarious, was, "No, man, he's a decent family man, citizen." In other words, he's not an Arab. That means he's a decent family man. The foot in mouth there by McCain was hopefully unintentional. However, the point remains, Barack Obama, although people couldn't say, "I hate him because he's black," they could say, "I don't like him," or "I hate him because he's Arab." He was retranslated into a racial discourse for the 21st century, where the hatred of a particular ethnic group is still allowed. It's just transferred from black to Arab. Hillary Clinton, in her primary challenge against Obama, famously went on an interview and addressed allegations that Obama was allegedly Muslim and not Christian. What did Hillary Clinton say? She said, "He's not Muslim, as far as I know." The pregnant pause left a question that resonated during all 8 years of President Obama's term, where many individuals, particularly those who disliked Obama's policies, felt that he was in fact Muslim and not Christian. Mitt Romney famously said during his challenge against Obama, "No one's ever asked to see my birth certificate." And of course, famously, Donald Trump rose to political prominence through his constant beating of the birth certificate trope, questioning whether, in fact, Obama was a legitimate president and whether, in fact, he was natural born and eligible to be president. There's deep irony in that, because at the very same time that there was this massive resonance to Trump's birther campaign, there was no question about whether Mitt Romney was an American citizen or a rightful presidential candidate, even though his father was born in Mexico. There was no question about John McCain being a rightful American citizen and a loyalist, even though he was born in the Panama Canal Zone. No questions whatsoever. Oddly enough, the only other individual who has faced questions about their eligibility for the presidency in recent presidential elections has been none other than Ted Cruz, an individual of Cuban descent, who faced questions as to whether he, in fact, was a natural-born U.S. citizen. To this day, huge numbers of individuals, particularly those who disagree with Obama's policies, believe he is a Muslim, and huge number of individuals believe, in fact, that he was not born in the United States. These questions were asked of Obama and yet not asked of similarly situated white candidates, creating a double standard and reflecting the fact that Obama was, in fact, treated differently. Although his blackness was not overtly attacked because it could not be politically acceptable in these times, his otherness and his foreignness were attacked, and suggest that the trope of color blindness has, in fact, continued to be betrayed despite the protestations of the post-racialists. Now let's look at how the trope of color blindness came about. And for this, we're going to turn our attention to some American constitutional history. The 14th Amendment, of course, contains the Equal Protection Clause, and it states that no state shall deny to any person within its jurisdiction the equal protection of the law. Very famously, in Plessy v. Ferguson, however, the Supreme Court held that segregation did not violate the Equal Protection Clause. Famously, the Supreme Court held, of course, that separate but equal was perfectly okay, despite the fact that separate hardly ever meant equal. In a very famous dissent by Justice Harlan, the trope of colorblindness was raised. This is what Justice Harlan wrote. "In the view of the Constitution, in the eye of the law, there is in this country no superior dominant ruling class of citizen. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. This very powerful dissent by Justice Harlan helped formulate the desire to overrule Plessy v. Ferguson, and eventually that became the majority view adopted by Brown v. Board of Education in 1954, when segregation was finally deemed unconstitutional and a violation of the 14th Amendment. The irony, of course, is that Justice Harlan, if you read the rest of his opinion, was no progressive as far as race goes. In fact, he took pains in his own dissent to Plessy v. Ferguson to note that the white race was still actually superior. He wrote, "In prestige, in achievements, in education, in wealth, and in power. So I doubt not it will continue to be for all time." So it's not as if Harlan was this great progressive, but nevertheless, he introduced this idea of colorblindness and the idea that the Constitution demands colorblindness. This was picked up by Brown v. Board, and of course famously became part of the Brown v. Board decision. But in more recent years, in the 1980s, 90s, and right into the years of the Rehnquist and Roberts courts, this trope of colorblindness has now been used in a different way, not to strike discriminatory policies against racial minorities, but rather to strike remedial race-based policies on the grounds that they are discriminating against whites. So, affirmative action, for example, hangs on the threads by a single vote of the Supreme Court. And in many ways, many affirmative action policies have already been struck. So, for example, in 2007, the Supreme Court struck the use of affirmative action at the secondary school level in the Parents Involved in Community Schools versus Seattle School District No. 1 case. There, Chief Justice Roberts, in his majority decision, invoked the language of colorblindness and said, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. A tautological statement that has, in a sense, a lot of appeal at first blush. In Grutter v. Bollinger, the Supreme Court narrowly affirmed the University of Michigan Law School's affirmative action program by a 5-4 decision, but in it, Justice O'Connor said that affirmative action should not be around much longer, maybe perhaps only 25 years. And in fact, in the dissents, both Justice Thomas and Scalia brought up this issue of color blindness again. Thomas cited Harlan's Plessy dissent, and he wrote, "Our Constitution is colorblind and neither knows nor tolerates classes among citizens, and as a result should not be discriminating against white people by giving advantages to non-whites in affirmative action policies for entrance to colleges or law schools." Scalia wrote, "The Constitution prescribes government discrimination on the basis of race, and state-provided education is no exception." Similarly, we've seen affirmative action struck in government contracting. In Adirondack Constructors, Thomas wrote, "Under our Constitution, the government may make no distinctions on the basis of race." And Scalia wrote, "Under our Constitution, there can be no such thing as either a creditor or debtor race. The concept is alien to the Constitution's focus upon the individual." And then finally, of course, Justice Roberts, in striking Section 4 of the Voting Rights Act in the Shelby County versus Holder case in 2013, wrote, "The country has changed." And here, post-racialism was implicit in the court's denunciation of the coverage formula under the Voting Rights Act, which the court basically characterized as being based on a 40-year-old facts having no logical relationship to the present day. However, before we embrace this notion of color blindness, and in fact, it is, I believe, appealing at first blush, it's worth remembering other occasions in which color blindness has been used as a vehicle not to uphold the rights of minorities, but to limit them. Very famously, post-Civil War, the Senate and the House passed civil rights legislation to help basically secure the equality of the newly freed slaves, the African Americans. However, this civil rights legislation was struck as unconstitutional by the Supreme Court in a very famous case called the Civil Rights Cases in 1883. Justice Bradley, in striking the Civil Rights Act, actually raised the trope of color blindness. He said there should be no special favorites under the law, and he viewed civil rights legislation as giving special favoritism to African Americans. He wrote, "When a man has emerged from slavery and by the aid of beneficent legislation has shaken off the inseparable concomitants of that state, there must be some stage in the progress of his elevation when he takes the rank of a mere citizen and ceases to be a special favorite of the law, and when his rights as a citizen or a man are to be protected in the ordinary modes by which other men's rights are protected." He wrote that in 1883, an era where Jim Crow was reasserting itself in the South, where racial violence, such as lynchings, were taking place on a regular basis, where in no shape, measure, or way were African Americans remotely being treated equally to whites. And yet he said, this is ridiculous to give them special treatment. We need to be colorblind. So there is some reason to be somewhat skeptical of the trope of color blindness. However, this is particularly so when we compare it to modern Supreme Court and lower court jurisprudence in three other areas. Areas where we have targeting of government policies against non-white individuals. In these areas, national security, immigration, and criminal law enforcement, the trope of color blindness suddenly vanishes. The very people who tell us that color blindness is required by the Constitution suddenly don't chirp anymore about color blindness. In fact, they allow specific racially conscious policies, which just so happen to target minority groups, to go on. Gone is the concern under affirmative action or the Voting Rights Act about the Constitution demanding that it not see race. So the very same courts that have told us that we have a colorblind Constitution tell us that one's Latino appearance is an absolutely relevant factor in determining reasonable suspicion for the purposes of an immigration sweep. We're told that one's Middle Eastern heritage is a perfectly suitable consideration when ascertaining when a transportation of a passenger might be inimical to safety. And we're told one's African American descent is a perfectly acceptable indicia of criminality without running afoul of the Fourth Amendment. In other words, we have two sets of law. Law where whites are being discriminated against, where the courts are increasingly standing up to this discrimination by saying the colorblind Constitution demands that the courts not look at race and the government not look at race. And legislation that actually targets minorities, where the trope of colorblindness goes suddenly silent. The result of this selective colorblindness is a reinstitution of white geographies. In other words, spaces characterized by an implicit hierarchy that privileges white racial identity. So let's examine these particular cases: white geographies and national security. Here, there have been a series of cases on national security issues where courts have not raised the specter of colorblindness at all. Very famously, in the First Circuit in 2008, in a case called Cercaria v. American Airlines, the courts, First Circuit, overturned a jury verdict in favor of an individual who had, based on his ethnicity, been kicked off of a flight on American Airlines. Mr. Cercaria was not Middle Eastern. He just had the misfortune of looking Middle Eastern. He was Portuguese American. He was kicked off for being suspicious. The pilot admitted the reason for it was because he looked Middle Eastern. And a jury came back and awarded him a large sum of money in damages. The First Circuit reversed the entire jury award and found there could be no liability. Why? The court effectively held that Mr. Cercaria's Middle Eastern appearance was a perfectly sound basis for consideration in determining whether he was a threat to the safety of the passengers and whether it was needed to kick him off the flight. Again, there was no talk of color blindness. There was no talk that the government sees no race. Here, his Middle Easternness was front and center in the decision to not fly with him, and the court held that it was perfectly okay to consider that. Other forms of government action in recent years have also come to light that obviously show the government isn't acting with color blindness. So for example, the New York Police Department has an ancestries of interest list that has been leaked. And this ancestries of interest list obviously doesn't refer to people in a colorblind way. Rather, it makes active use of color and in fact targets certain populations, particularly those of Middle Eastern and Muslim communities, for special scrutinization. There is no mention of colorblindness, and no court has ever suggested in these circumstances that we must have a colorblind constitution. There's also the famous case of Shoshana Hebshi. A few years ago, Shoshana Hebshi, in 2011, made the mistake of booking a flight on September 11th, 2011. She later on recounted that she thought she'd fly on that day because the tickets would be particularly cheap since it was the 10th anniversary of 9/11. Shoshana Hebshi is half Jewish, half Arab, and she looks Middle Eastern. On the flight, she sat next to two South Asian men. Those two South Asian men, unfortunately for them, also looked Middle Eastern. When those two South Asian men went to the bathroom in rapid succession, Ms. Hebshi, along with the two South Asian men, were forcibly held down, and their flight was escorted by military jets, taken to a special terminal. All the passengers were taken off, and she and the two South Asian men were scrutinized and accused of potential terrorist activities. She was force held for numerous hours in a cell. She was strip searched and utterly humiliated. What had she done wrong? Nothing. She had the misfortune of sitting by two men who looked Middle Eastern, and she looked Middle Eastern as well. Until then, she felt she had always felt welcome in our society. But she mentioned after that incident, she could no longer feel that way. That forever changed her view because she knew she was always going to be suspect. Why? Simply because of the way she looked. And there was no consideration on the part of the government of colorblindness in those actions. In criminal law enforcement, we've seen a similar lack of interest in terms of insisting on colorblindness tropes. Very famously, Senator Russ Feingold introduced legislation in the early 2000s to end racial profiling. How did the Senate respond? By not passing the legislation, not even giving it a vote. So, Russ Feingold introduced legislation in 2001, 2004, 2005, 2007. It never got enacted in law. In other words, because it never got enacted in law, arguably, racial profiling is still allowable. The US government refuses to condemn it. The Bush administration came close at one point to officially endorsing a policy that ended all racial profiling, but it did not adopt it. And in fact, the allowance of racial profiling in criminal enforcement is a policy that has been blessed by the United States Supreme Court. In a case called Wren v. United States in 1996, the Supreme Court held, in a case involving the stopping of an African-American man on supposed suspicion that the cops later admitted in a rare case that was related specifically to his racial identity. Quote, "We have never held outside of the context of inventory search or administrative inspection that an officer's motive invalidates objectively justifiable behavior under the Fourth Amendment." So in other words, in the context of racial profiling, we have no color blindness. In fact, racial profiling to date is arguably perfectly permissible, and we do not see the government acting to end it. Unfortunately, this position on racial profiling seems to give credence to the work of Derek Bell, a Harvard law professor who wrote for many years about issues involving race. He had a theory called the interest convergence theory. In his view, his cynical view, but unfortunately one that seems backed up by this selective color blindness, Brown v. Board of Education was only passed because we looked bad fighting a Cold War where we were not, in fact, giving rights to all of our citizens on an equal basis. And he suggested that based on that, basically, majority races will generally only support equality for minorities only when doing so advances the interests of the majority race. Such a view seems backed by the selective color blindness, as much as I like to think otherwise. Finally, with respect to the borders, courts have systematically held that in immigration sweeps, race is an absolutely permissible factor to consider. Starting point for this is the Brignani-Pons case from 1975, where the Supreme Court held the likelihood that any given person of Mexican ancestry is an alien is high enough to make Mexican appearance a relevant factor. Now, that case from the 70s was addressed again in a 2000 holding before the Ninth Circuit, where an individual of Latino descent was caught up in an immigration sweep. And the court wrote that Bignoni Ponce no longer applied. The likelihood that in an area in which the majority or even substantial part of the population is Hispanic, any given person of Hispanic ancestry is in fact an alien, let alone an illegal alien, is not high enough to make Hispanic appearance a relevant factor in the reasonable suspicion calculus. This holding seemed to cut back Bignoni Ponce and seemed to suggest that courts can no longer consider Latin heritage as a basis for an immigration sweep, at least in the Ninth Circuit. But unintentionally, this holding suggested no such thing. It suggested that where Latinos appear with lots of other Latinos in a primarily Latino-populated area in the United States, then their Latino appearance is not a permissible thing to consider for an immigration sweep. However, it suggested that when Latinos transgress the informal segregation of our cities and enter traditionally white cities or white towns, then their appearance is a perfectly reasonable basis for an immigration sweep. Now, lest you think that I'm reducing that to two stark racial terms, I present two other cases that followed up Montero Camargo, which held just that. In United States v. Manzo Urardo in 2006, the Ninth Circuit actually upheld the use of Hispanic appearance to target an individual of Latino descent when he was found in the northern Montana border town of Havre. What the court said was the earlier holding in Montero Camargo was not applicable because Havre, Montana is sparsely populated with Hispanics. So in other words, it's okay to be Latino in Santa Ana, but it's not okay to be Latino in Malibu. Similarly, there was a follow-up case in the same area, Havre, Montana, called Habib v. Caslew, where the federal district court held that the targeting of an individual for Arab appearance in Montana was also similarly permissible because it's unusual for someone to look Arab in Montana. The court wrote, to find constitutional merit in Habib's claim would blatantly disregard the reality that law enforcement officers must and are entitled to rely upon the observed behavior, personal characteristics, and appearances of others every day in meeting their responsibilities. It would be absurd for this court to declare that law enforcement personnel and border protection officers in particular were acting unconstitutionally if they availed themselves of their ability to distinguish between people based on appearance, i.e. race. Now, that may be the case. It may be absurd to demand that our officials be colorblind at the border in enforcing immigration laws. But if that's the case, then isn't it similarly absurd to suggest that after several hundred years of discrimination against individuals, including those of African descent, 20 years or 30 years of affirmative action can level the playing field despite a 22-to-1 wealth gap between whites and blacks that persists? Wouldn't it be similarly absurd to suggest that we have a completely colorblind constitution? We can't have it both ways. And in the rulings that I've just demonstrated, as I mentioned, the courts have effectively held that it's okay if you're Latino in Mexicali, but not in Malibu. It's okay to be Arab in Michigan, but not in Montana. Effectively, courts are creating differential rights for minorities based on whether they stay in spaces where there are others like them or when they transgress and enter places that are primarily white. Finally, we have the white geographies of Arizona, where effectively recent legislation has basically told non-whites that they are mere guests in the Grand Canyon state. HB 2281 has effectively banned ethnic studies in Arizona, and SB 1070, the Show Me Your Papers law in enforcing immigration law in Arizona, which has thus far been upheld, has effectively targeted individuals of Latino descent for special treatment for the enforcement of immigration policies. Now, The state of Arizona and its recent policies provide a case example of the reassertion of white geographies and the selective use of color blindness in both political and legal discourse. Specifically, we're going to look at two provisions that have recently passed in Arizona. First, HB 2281, which I previously alluded to, which is Arizona's ban on ethnic studies programs in public schools. And second, SB 1070, Arizona's more famous law that basically created an ability for Arizona to enforce immigration laws through the asking of law enforcement officials for people to, quote unquote, show them their papers. This is also known as SOLENA. That's the law. Let's start with HB 2281. HB 2281 effectively ended a number of successful ethnic studies programs in a variety of municipalities in Arizona. These programs were programs targeting, generally, individuals of Latino heritage to celebrate not just various people in history that happened to be white, but also individuals in history that happened to be Latino and contributed both to American society as well as world society and world culture. However, these efforts were objected strenuously as a form of an extension of affirmative action to curricula. And effectively, they were seen as an outmoded effort where the government was subverting the notion of color blindness in the political curriculum. Attorney General Tom Horne was the chief architect of the legislation, and he argued in favor of it in a famous 2007 letter. He wrote, "I grew up in the civil rights era. In the summer of 1963, having just graduated from high school, I participated in the March on Washington, in which Martin Luther King gave his famous speech that his son should be judged by the content of his character, not the color of his speech. I have held on to this ideal in the face of subsequent fads, political correctness, identity politics, racial preferences, and ethnic studies." Now, in an interview with the New York Times following the passage of HB 2281, Horne similarly rebuked allegations that likened him to Eugene Bull Connor, Birmingham's notorious commissioner for public safety who rose to prominence in the face of bigotry in the 1960s. Once again, Horne invoked his attendance at the March on Washington and then said of his opponents, "They are the Bull Connors. They are the ones resegregating with their ethnic studies programs." Now, Horne's tactic was eerily reminiscent of the words of President Andrew Johnson some century and a half ago when he vetoed the 1866 Civil Rights Bill, which we've talked about earlier. Johnson and his allies also argued that the real racists were the ones who were forcing the government to be race conscious, to be providing, quote, special protection for blacks instead of whites. What did Johnson write? "In all our experience as people living under federal and state law, no such system as that contemplated by the details of this bill has ever before been proposed or adopted. They establish for the security of the colored race safeguards which go indefinitely beyond any that the general government has ever provided for the white race. The distinction of race and color is by the bill made to operate in favor of the colored and against the white race." So, Johnson invoked colorblind sentiments, but they were clearly a little bit disingenuous in light of his active support for slavery. Horne and his supporters were notably absent in citing the dictates of the colorblind Constitution when they contemplated the passage of SOLENA, the bill that passed right around the same time, SB 1070. These are the show me your paper laws that were passed in Arizona. This legislation was passed in 2010, and of course, occurred not coincidentally at the same time of the ban on ethnic studies. Effectively, both SB 1070 and HB 2281 help basically vindicate the idea of color blindness by basically saying the educational institutions of Arizona will not consider race. But at the same time, in invoking color blindness, they're effectively giving preference in the schools to a curriculum that has traditionally preferred white history, preferred modalities or subjects that are particularly notable for how they emphasize the contribution of whites to American history and de-emphasize the contributions of non-whites. With respect to SB 1070, however, there's also deep irony. Those who supported SB 1070 said very clearly that it clearly does not condone racially discriminating or racially profiling individuals because you cannot take race into account, they said. And in fact, they put in some specific language that they purported addressed the issue or the risk of using SB 1070 on racial grounds by targeting individuals with brown skin as being un-American or therefore subject to specific immigration scrutiny. What did the legislation say? Well, it basically said that nothing in this law that the law cannot be enacted in any way that violates the Arizona or federal constitution or federal law. And based on that, they said, well, clearly, because federal law has the Equal Protection Clause, we aren't allowing discrimination to be used in the Show Me Your Papers provision. Of course, that betrays what we've talked about earlier today, which is that, in fact, the federal government has systematically refused to end racial profiling, that, in fact, the Supreme Court's interpretation of the Equal Protection Clause thus far, in fact, allows for racial profiling, and, in fact, the cases in which it allows for racial profiling relate to criminal law enforcement, national security, and immigration. So the alleged saving clause for SB 1070, which made it non-discriminatory, in fact did no such thing. Because legal discourse has been selectively colorblind, government can still target individuals of non-white descent in immigration law, under 1070, or under national security law, or under criminal enforcement law through the cases that we've discussed today. So, in short, as we've seen, Barack Obama's two-term presidency was actually a very important moment in American history. It did hail progress. It did show some improvement in race relations. And the takeaway message here should not be that, in fact, things are getting worse rather than better. However, the narrative that we are getting better on race in every single way is similarly betrayed by the data on economic disparities between white and black, and also betrayed by the fact that post-racialism and the trumpets of post-racialism sounded, unfortunately, before their time. We have not moved on from race. The events of the Black Lives Matter, the events of Charleston, the events of Ferguson in recent years, the proposals for a Muslim ban, and a building of a big, beautiful wall, all suggest that race is unfortunately still a major issue in American society. It still dominates the daily headlines, it dominates the political discourse, even if not in traditional ways, in subtle ways as subtext. And it continues to dominate the legal discourse. As we've seen, courts have invoked a selective notion of colorblindness. On one hand, courts have hewed to colorblindness and adopted the dissent from Plessy v. Ferguson, although not to just outlaw segregation, but to also strike attempts at remedial action aimed to help minority groups from suffering of decades, if not centuries, of discrimination. Colorblindness has been invoked to end affirmative action, certainly at the secondary school level, in government contracting, and if one vote on the Supreme Court changes, in college and university law school admissions. However, although courts have been adamant about colorblindness in these contexts, in a series of other cases, there has been a notable absence of any discussion of colorblindness. Although courts have given us grandiloquent language involving colorblindness in the context of affirmative action or the Voting Rights Act, they suddenly go silent when confronted with explicit color-conscious activity by the government in the context of immigration, national security, and criminal law enforcement. Now, in all of these areas, courts have upheld activity that targets, in all of these cases, non-white individuals for special or differential treatment, usually negative, on the basis, at least partly, of the color of their skin. Gone are the advocates, the obstreperous advocates for color blindness in these contexts. No one is saying in these contexts, well, the government should be colorblind and a person's race shouldn't matter. However, this selective color blindness system has effectively helped enable and perpetuate white geographies and white supremacy, an implicit view of white racial advantage throughout our schools, in our schools, on the highways, near the borders, on the airplanes, and in other spaces of American life. My final thought is that in the past, we've learned that government-based discrimination is a wrong. It is something terrible, and it has caused many, many problems in our society throughout the years. Government-condoned discrimination should not be a template for our future. It has not served us well in the past.